Be seated, folks. Good morning, folks. Welcome to Division 1 of the Court of Appeals. My name is Judge Ted Tao. To my right is Judge Dan Taubman, and to my left is Judge Michael Berger. Together, we are the division assigned to hear our first matter set on the docket today, and just so you folks know, we will be taking a break after the first case to reconstitute the panel. Our first case on the 9 o'clock docket is 17CA2193, DFW Group versus Roberts. Are the attorneys present on that case?
Yes, Your Honor.
By now, you should have been provided with a handout regarding our procedures. Does anyone have any questions about those procedures? Seeing none. While we will likely refer to attorneys as counsel, we may at times use your names or names of parties. If we mispronounce any name or use a gender pronoun different than that which is preferred, we do apologize. Please simply correct us and we'll endeavor to get it right from then on out. Also, please remember that the arguments are being live streamed on the internet and will be archived. So if there is sensitive information, please take care in how you discuss such matters. And on that note, if anyone in the courtroom does have a cell phone, please make sure it is turned all the way off, not just silenced. This will not only ensure that it does not interrupt us during the proceedings, but at times, especially when cell phones get close to the podium, it can interfere with the streaming and the sound for people listening. Each side does have 15 minutes for argument. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. With that, let's begin.
Good morning, Your Honors. Christopher Conant for DFW Group, Triple LP, registration number 40269. I will try to reserve 5 minutes for rebuttal. May it please the Court. The issues before the Court today revolve around the application of primarily our state's foreclosure laws, as well as our rules of civil procedure. There's been a lot of talk in the briefs, in the answer briefs, about various risks and the relative positions of the parties and equity in this case. So I want to give the Court just a brief background on the foreclosure process and the situation that my client finds itself in when it goes to bid on a property at a foreclosure sale. 2 business days before a lender forecloses through the public trustee, the lender has to give the public trustee a bid reflecting how much is owed to the lender, and then directing the public trustee as to where to start the bidding at a foreclosure sale. Public trustee then publishes those bids, and my clients, primarily foreclosure investors, then review what we call the sale notice, and to see what properties are going to sale that week. And they, at that point, have approximately 48 hours to go inspect the properties that they want to bid on, and review the title to understand when they buy a property at the foreclosure sale, what they're actually going to get. And when I say they get to inspect the properties, the foreclosure investors are not entitled to get a physical inspection of the property. At best, they can drive by the properties. So my clients take a lot of risk with regard to the physical conditions of the properties. These properties could have serious foundation issues, they could have be contaminated with meth, they could have cats living in the walls. There's a whole host of physical issues.
Mr. Conant,
Yes.
let me ask you, we just don't have much time, frankly,
Sure.
and I really want to get to the issues.
Okay.
Does a Rule 105 court have equitable authority to set aside a foreclosure?
Under certain circumstances.
Isn't this the prototypal circumstance of setting aside a foreclosure?
No. The case law on this issue is pretty darn clear, Your Honor. And it goes back from Johnson v. Smith, is also, in addition to, I believe it's National Bank of Lakewood, it says a public trustee foreclosure sale may only be set aside when there's fraud, deceit, or collusion on the part of the purchaser at the foreclosure sale. Those are the circumstances under which a public trustee sale may be set aside after it's completed. A public trustee foreclosure sale is completed once all redemption periods have expired. In this case, my client obtained fee title to the property on May 22nd. That's when the foreclosure sale was completed, because that's when all redemption periods expired.
But by that date, your client had notice of a defect, right?
Well, there's a factual issue on that, Your Honor.
How could there be? There was a lis pendens that was filed. How could there be any factual issue as to whether your client had notice as of the time when you say title was confirmed? I don't understand how you could claim that you didn't have notice at that point.
We had notice. My client allegedly had notice. And I say allegedly because all of this was done simply through affidavits of counsel, hearsay affidavits of counsel.
The recordation of a lis pendens isn't a hearsay declaration of counsel.
That's true, Your Honor. Number one, the lis pendens in and of itself was inappropriate in this case because it was filed in connection with a Rule 120 proceeding. A lis pendens can only be filed by statute. I believe it's 3835, I want to say 209, or I believe it's 209, after a pleading is filed asserting a claim for relief. A Rule 120 motion is not a pleading. Rule 7 says what pleadings are, and a motion is not a pleading. So the lis pendens itself was inappropriate. But in any event, Your Honor, my client purchased the property in early May. At that point, all you had to do, so my client's rights were vested at that point. All that had to happen was the running of the redemption periods.
So the running of the redemption period is so the borrower can say, well, never mind, I've got the money now, let me save my title, right?
No, Your Honor, the foreclosure and redemption statutes were changed in about 2008. There's no longer an owner redemption period.
Okay.
There is only a junior lienor redemption period.
Only a junior lienor.
Only a junior lienor
So the
redemption
primary lienor coming in during the redemption period and saying, oops, never should have happened, is not sufficient for redemption?
Correct, Your Honor. There is a statute in the, I believe it's 3838, I want to say 111, which allows a foreclosing lienor to unwind a foreclosure sale, but only under the circumstance when the foreclosing lienor is the successful bidder at the sale.
Do you have a case from anywhere, from any jurisdiction, that under similar facts, namely where this foreclosure sale never should have taken place because there wasn't a default, that a court sitting in equity does not have authority to set aside the foreclosure?
We have, Your Honor, the Johnson case and the Lakewood Bank case, which say that the only circumstances under which equity can be used to set aside a foreclosure sale is where there is fraud, deceit, or collusion on the part of the purchaser of the foreclosure sale.
Did those cases involve facts similar to these?
I don't believe so, Your Honor. There was the Green Tree Servicing case, Your Honor.
Well, before we go there, so is there a case anywhere in any American jurisdiction where under similar facts a court has failed to set aside a foreclosure?
Not that I'm aware of, Your Honor. We have circumstances under which these large servicers and their law firms that process these foreclosures run to the Rule 120 court when they find out there's been a problem, and they try to set it aside in the Rule 120 proceeding. And they've gotten away with it a lot of times, but I think if you've seen in the briefing, that's not an appropriate use of the Rule 120 proceeding. Here, we had a Rule 105 action, but none of the procedures that would be attendant to a Rule 105 action were followed in dismissing all of these claims.
Let me ask you about your damages claim.
Mm-hmm.
Did you articulate at any point what claim damages you had as a result of what I would call a mess?
We articulated in our third-party complaint the scope of our damages, which included our carrying costs, the risks that we had, our insurance costs. I believe we identified the insurance costs in our pleading as well. My client took, the funds aren't just cash. These purchase funds that they bring to the public trustee sale, they are cash, but obviously my client's source of funds are typically through other means of financing. So there's significant carrying costs on this money. And so we incurred that, my client incurs those costs. The other component of the damages is the expectation damages here, Your Honor. We know what the fair market value of this property was. It was purchased months before by the Roberts for approximately $410,000. So my client's damages are the spread between the $210,000 purchase price and the fair market value of the property, which is easily ascertainable.
What do you understand the trial court's procedural basis was for, and I want to focus on your damages claims.
Mm-hmm.
What was the procedural basis as you understand it, for the trial court's dismissal of your damages claims?
The trial court said that because it granted Wells Fargo's motion to set aside the foreclosure sale, a motion filed in the Rule 120 proceeding, that all of the, quote, motions, those are the district court's word, all the, quote, motions in the Rule 105 action were then rendered moot, and therefore it dismissed the case. It was a very bizarre procedural machination by the district court.
Were there pending Rule 12 motions that the court ruled on?
There was a pending Rule 12 motion filed by Wells Fargo that my client responded to. It was a Rule 12b5 motion to my client's third-party complaint, but there was no ruling on that 12b5 motion. The district court judge said it was moot because it had unwound the foreclosure sale in the context of the Rule 120 proceeding. It's a very strange procedural posture, Your Honor.
Counsel, let me ask you on the issue of consolidation.
Mm-hmm.
First of all, let me state a premise, and then you can agree or disagree. Whether or not something is formally consolidated pursuant to Rule 42, cases can certainly be joined for purposes of scheduling on a trial court's docket, correct?
Correct.
If that's all that had been done, would there be a problem in your eyes?
No.
Is there any difference?
Yes.
How does consolidation change things?
I think what the court did here was use the mechanism of consolidation to enter a substantive ruling disposing of what I'll call, quote, the quiet title action. Because the quiet title action contained more than just quiet title claims for relief. It included an eviction action and monetary claims, third-party monetary claims for negligence, negligent misrepresentation, fraud, and then deceptive trade practices by my client against Wells Fargo. So what I believe the district court here did was use the tool of Rule 42 to use the Rule 120 proceeding to say, under the rubric of Rule 120, I'm going to say that this foreclosure sale was void, and as a result, this quiet title action, this lawsuit with third-party complaints and counterclaims and replies is all now rendered moot.
But even if he hadn't consolidated, if he was going to take that step, he could have done it anyway, right?
I doubt that, because under Rule 120, any order issued in a Rule 120 proceeding is without prejudice to any other claim for relief. So it would have been interesting, and it would have raised more issues, but I think ultimately the court ruling just in the Rule 120 proceeding, entering an order in the Rule 120 proceeding, saying this foreclosure sale is void, I think that order would have been a nullity. It would have clouded title more, because as a legal matter, any order entered in Rule 120 proceeding has no prejudicial or preclusive effect.
Mr. Conant,
Yes.
in your brief, you seem to assume that all of the orders that Judge McGahee entered in the Rule 120 proceeding were beyond the scope of Rule 120.
Yes.
But I'm not clear from your brief what procedure would have or could have been used apart from what was actually used here. Can you tell us?
Yes. What Wells Fargo should have done is not run to the Rule 120 court with a motion to set aside the foreclosure sale. If the relief that Wells Fargo wanted should have been initiated through Wells Fargo filing a complaint asserting a quiet title claim for relief and whatever other injunctive relief Wells Fargo wanted, and then we could have had, my client could have had the luxury of the full panoply of the rules of civil procedure.
But how is that different from what actually happened? Because there was, in fact, a Rule 105 proceeding, quiet title proceeding that was filed.
Correct, but none of the typical, there was a motion, a 12b5 motion filed by Wells Fargo to dismiss my counterclaims, but there was no ruling on that motion.
Well, no, I'm not asking you about that. I'm just asking about your statement that in lieu of a Rule 120 proceeding, the proper procedure would have been to file a separate Rule 105 proceeding. Is that a correct statement
Yes.
of what you were saying?
Yes.
So I'm asking, how is that different from what actually occurred? Because there was, in fact, a Rule 105 proceeding that was filed.
The Rule 105 proceeding was filed, but it was then summarily dispensed with through a motion filed in the Rule 120 proceeding that assumed a number of facts that, frankly, my client wanted to dispute and believed it was appropriate to dispute. And then it's a function of what's the appropriate standard of review on appeal. Let's assume that the Rule 105, that Judge McGahee wanted to treat the motion to set aside the foreclosure sale as a Rule 56 motion. I never had those procedures. We were never given notice of that. That's effectively what happened.
But we're instructed to ignore irregularities in the trial court, errors by the trial court that don't actually prejudice a party. And I know you disagree with the proposition that it was appropriate or is not appropriate for the court to set aside the foreclosure sale. I think you have a heavy burden there, to put it mildly, that under these facts it was not appropriate for the court to set aside the foreclosure sale. If that's true, contrary to your belief, isn't this a no harm, no foul situation? Even if the court ran roughshod over the rules of civil procedure, does it matter in this particular case?
Yes, it matters. My client, because let's assume the foreclosure sale was properly set aside, which I disagree, because I think the Green Tree Servicing case says that 3835-124 provides the legal remedy to a person who was inappropriately foreclosed upon in a situation like this, which is a monetary claim against Wells Fargo and, frankly, their title insurance underwriters. But my client had significant reliance costs on Wells Fargo's bid in putting its money out there, incurring its carrying costs, incurring opportunity costs. And it had monetary claims for negligence, negligent misrepresentation, fraud. I don't see how any of those claims could be properly disposed of as against Wells Fargo simply because Wells Fargo screwed up and then my client relied upon it. My client's damages are significant. They're in the hundreds of thousands of dollars as we pled in the complaint, which was never ruled upon. I'll reserve my 5 seconds for rebuttal. Thank you.
Counsel.
Good morning, Your Honors. May it please the Court. James Eccles on behalf of the appellee, Wells Fargo Bank. And as trustee, I'm going to try and reserve 5 minutes for counsel for the Roberts. I'd first like to address DFW's pervasive contention in the appeal and the briefing and somewhat now that the trial court lacked authority to set aside the sale in the context of the Rule 120 action as opposed to filing a separate action. This argument has been perplexing to us because it ignores the fact that there was this separate action, as I think you kind of alluded to, and the case was consolidated with this quiet title and a declaratory judgment actions. Contention is also difficult to reconcile with DFW's arguments that any order in the Rule 120 is non-appealable, it's without prejudice, and yet they're on one side saying this order to set aside was entered in the context of the Rule 120, but they're also appealing that now, so that doesn't really follow.
Mr. Eccles, let me just cut to the chase here.
Sure.
I'm hoping you can help me. I'm having an awfully hard time understanding why Wells Fargo should be immune from the damages claims that resulted from Wells Fargo's either negligence or otherwise improper conduct. Can you tell me what I'm missing?
Well, so I think that goes to kind of, so the cases were consolidated. I think this really, the best example of this case is here, the most analogous is the Moreland case, which there were similar circumstances. In that case, consolidated several other actions, and the court there, even though the redemption period had ended, said that it could still be extended because based on kind of looking at the totality of the circumstances and said that the court had discretion to exercise its equitable jurisdiction to remedy the wrong there, which was similarly erroneous ruling in the Rule 120.
Right, but I'm not talking about setting aside the foreclosure.
Right.
I'm talking about after the foreclosure was set aside, why doesn't DFW have a right to pursue its money damages claims?
Right, and I apologize, I am getting there. I guess my point there is, when you take all of these together and say under Rule 42, consolidate cases, and under the equitable power to fashion a remedy that fixes what happened, the court here did just that, and it just decided, well, in the Rule 120, there was no default, there was no power of sale, there was nothing underlying the order authorizing sale that could have allowed the sale to happen. And it said it was a nullity. It used that term exactly. And I think when the court declares it a nullity, it's as if it never happened. And if you look at the Taikei case we cite, that's what it says. It says you need to return the parties to the status quo ante before the sale occurred, because it's like it never happened.
But the court's order didn't do that. I mean, to the extent that DFW had reliance costs or expectation damages, the court's ruling demonstrably did not do that. That's the problem. That's the problem I'm having.
Right. What in our view, what the court did was said it's a nullity. We're going to return the parties to where they were. Here's your bid back, DFW. If the sale, your claims in your third-party complaint, and they say this in the briefing, they cite, one particular passage of their third-party complaint. It says, we are going to have damages if the Roberts are successful on their quiet title action. Well, if the sale never happened, there doesn't need to be this quiet title action. The quiet title action of the Roberts was also dismissed. So I think that's the only thing they're pointing to in the DFW's arguments is that, well, if the Roberts succeed, then we have damages. They haven't said that it was an error for the court to say that it was a nullity in the first instance. They never argued that. And I think it follows from there that the court could say, all right, the sale itself was a nullity, but you go back as if the sale never happened at all. So what happens? They get their money back, Roberts get the property, and the claims, kind of arguing about all this other stuff are dismissed. And I think, and I haven't seen any support in the brief certainly for the proposition that the type of damages that they're claiming, these expectation damages, are something you can get in these contexts. It's very speculative.
But aren't they entitled to litigate that? I mean, the judge, as I understand the trial judge's ruling, he said it's moot, everybody go home. No one really had a chance to argue whether or not these were the types of damages that would be recoverable. The judge just precluded that, and that doesn't seem to be consistent with the Colorado Rules of Civil Procedure.
I think the court did consider it. I mean, I know it's not in the order, but I think the court can take all of these circumstances under consideration. It can also, under Rule 42 of the Rules of Civil Procedure, make any orders in a consolidated case that tend to, avoid unnecessary costs and delays and things, and it has some authority there to look at all these issues and decide, I'm going to put the parties back to where they were as if the sale never happened.
Isn't that the same thing as somehow saying, I'm going to put the parties back to where they were as if the car accident never happened? It did happen. It may not have happened for purposes of title, but it happened for purposes of their foregoing the use of that money for some period of time for at least an argument for expectation damages. They list about 6 different categories of damages in their complaint, as I recall.
Right.
And you can't undo time in the actual sense of causing damages. You can only do it in the sense of whether there's a legal effect on the title, can't you?
Well, I understand the point, and I mean, we would argue, and I know I get your point that maybe this is something that should have been argued, allowed to be kind of disputed down in the trial court, but there haven't cited any authority that these types of damages are something you can realize, and the cases that we've seen suggest that in these circumstances, the only types of damages that you can actually get in these circumstances are one, your money back, to potentially interest, which I think Wells Fargo offered to provide to them, although there was a very short window, between when the sale happened and when it said we need to free to do this, but.
Well, none of this has anything to do with whether or not there was error in dismissal of the money damages claims. I mean, the fact that they might have offered something,
Well,
you know, we can't take that into account.
Right. Well, yeah, that was, I guess, an aside. My point was, in our review of the case law, the only damages that a foreclosure investor may be entitled to is if they did some repairs to the property, improved it. In this case, they never got the property. The Roberts have been in possession of the property and have been making improvements, I understand, themselves, but DFW never had that property, and that, in our review, are the only types of damages besides getting the bid back that is allowable under Colorado law. I would like to kind of get back to this suggestion. I think, to be clear, Wells Fargo's position is the court in the Rule 120 could have vacated the sale solely in the context of the Rule 120. That's the Baker's case and the Takai case. But we don't really need to get there because in here there was a separate action, and I think there might be an implication or suggestion that this was somehow improper because Wells Fargo didn't refile the motion or file for that relief again in the context of the Rule 120 or context of the consolidated cases, but there's no authority cited for that, and again, Rule 42 allows.
Could you explain to us the lis pendens that Wells Fargo filed? I didn't quite understand that. What was the basis for the lis pendens?
I think the list pendant was filed to alert, the world that there's an issue here, that this sale was not proper, that there's going to be some litigation concerning that issue. And I think that was the only thing that would have.
So what pleading did the list pendens relate to? I mean, normally, you file a 105 complaint, you say, this action involves title to property, so here's my lis pendens. What exactly was the pleading that Wells Fargo filed that the lis pendens was intended to give the world notice of?
I think I didn't file the lis pendens, so I can't tell you all the reasons, but my understanding is that, I guess, a motion in a Rule 120 is kind of similar to a plea, and that's how you initiate that action. And the motion to set aside was, again, just giving notice of this. And, there was a separate action. I think they could have done that as well, and ultimately that's kind of where that was all litigated. But yeah, I think that's what that related to. Just really quickly, I want to give some time. I did want to point out one thing about I think the Johnston case, or the Johnson case, cited by Mr. Conant today and in the briefing. There are two seminal, and I think only two, Colorado cases describing the circumstances under which the court may allow a redemption period to be extended or a foreclosure sale to be set aside. One is Johnston, but the other is the Moreland case that we talked about. And Moreland remains controlling precedent. In fact, Johnston, it's pretty much Moreland is the primary basis for Johnston. In Johnson, it cites Moreland for the proposition that in appropriate circumstances, court of equity may allow redemption after the statutory time period is expired. And then it also, in this quote that we're talking about, where we first see in any case that there must be circumstances, it says such as fraud, deceit, or collusion by a purchaser. It cites Moreland for that proposition. Moreland doesn't involve typically what we think of as fraud, deceit, or collusion. The main issue there was the court found that the Rule 120 court had erred by not allowing the borrowers to present their evidence of lack of default. So really, and I think Moreland's much more on point, it takes the totality of the circumstances into consideration and says, when you have an error like this and these other circumstances, you can look at the effect on the other parties, you could look at that and you can decide to set aside the sale, or in that case, extend the redemption period. Thank you.
Your Honors, may it please the Court, Patrick Hickey on behalf of Taylor and Tiffany Roberts, as well as Freedom Mortgage Corporation, bar number 41592. I only have 3 minutes, and so I'm obviously going to be very brief. One point I want to make here is that under no circumstances should the FED action against the Roberts be reinstated, regardless of whatever determination the court makes as it relates to damages claims against Wells Fargo. There is simply no factual basis under any scenario through which the FED action should ever go forward. So I guess with that off the top, unless there are questions on that, I wanted to touch a little bit about what happened in terms of Wells Fargo and also DFW and this question of damages. When DFW became aware of the motion to set aside, the motion to set aside did include a statement that Wells Fargo would provide not only the money back, but also the interest. And everything that happened from there is a failure to mitigate damages. Excuse me, so there
Can we
is-
consider this? I mean, is this proper before us? It may be proper before the trial court or remand, but how can we consider this type of information?
Well, that's a fair point, Your Honor. I guess I would say the other thing that hasn't been discussed today is that Judge McGahey specifically cited to Rule 56 in his order when he determined that all other claims were dismissed with prejudice. And this wasn't a normal motion to set aside. There was a hearing that happened after the motion was filed. Judge McGahey brought the parties in and said, let's set a briefing schedule. You can present any evidence that you want to present on any of this through your briefings, and the parties did that. So essentially what the ongoing claims would be are claims that have already been dismissed essentially pursuant to a Rule 56 motion. So
But
if you...
Is a dismissal, well, granting a Rule 56 motion is granting a summary judgment motion.
Correct.
Are there cases where summary judgment is granted on mootness as opposed to on the merits?
I think that's an important distinction, Your Honor. The mootness was only to the motion to dismiss. The judge says all pending motions are moot. He did not say the claims are dismissed because they are moot. So that's not what Judge McGahey said. And so I think the reading that I would encourage the court to interpret is that Judge McGahey made essentially a summary judgment type motion finding there were no, and also an equitable finding under Rule 105, saying I have all the evidence that I need to determine the merits of these claims without additional evidence. And I haven't heard any evidence that there are factual disputes about the liability portion of the claims. And so I think to say that Judge McGahey just said, it's all moot is not actually an accurate reflection of what was said in the order. And then the other thing, just briefly here, my last 10 seconds, so I'd just like to remind the court, is that DFW had notice of the Roberts' ownership in the property, and despite hitting the motion, immediately went to do an FED action. So again, I just encourage the court. Thank you.
Talk fast, counsel.
5 seconds. A couple things, Your Honor. First, on the Moreland v. Marwich case, that case involved deception. It was the bank imposing leading the borrower into potentially misleading the borrower and then submitting an unreasonably low bid.
That's your time, counsel.
I'm sorry?
That's your time.
Thank you.
Thank you. All right. Thank you, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. We will now take a brief recess so that we may reconstitute the panel for our next case. The bailiff may so announce. Be seated, folks. Good morning again to those of you who sat through the first argument. Again, this is Division I of the Court of Appeals. My name is Judge Ted Tao. To my left is Judge Dan Taubman, and to my right is Judge Joanne Vogt. Together, we are the division assigned to hear the matter set on our 9:30 docket, which is 17CA2369, Louisiana Purchase versus American Family. Are the attorneys present on that case? And again, you should now have been provided with a handout regarding our procedures. Does anyone have any questions about those procedures? We will likely refer to counsel or to attorneys as counsel, although we may use names of counsel or of parties. If we mispronounced any name or referred to any individual by a gender pronoun different than their preference, we do apologize. Please simply correct us and we will endeavor to get it right from then on out. Please remember that the arguments are being live streamed on the internet and will be archived. So if there is sensitive information, please take care in how you discuss such matters. And on that note, if anyone in the courtroom has a cell phone, again, we remind you, please turn it all the way off. It does both run the risk of interrupting us as well as interfering if it gets too close to the podium. It'll interfere with the streaming. Each side does have 15 minutes for argument. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. With that, let's begin.
Thank you, Your Honor, and may it please the court, Robert Fishman, 21842, on behalf of the appellants. Two primary issues in this appeal. The first is whether American Family's duty of good faith and fair dealing encompass the obligation to disclose to us its subrogation activities. And the second question is whether, if American Family had that duty, is there any evidence in the record that a jury could rely upon to conclude that that duty was breached? On the first question, the starting point really in answering the duty question is to recognize Trimble, FICO, FAM, that the duty of good faith and fair dealing at bottom is a question of reasonableness under the circumstances. What would a reasonable insurer do given the facts of a particular case? And I know the court is familiar with the facts here. There really are just a handful of them that are relevant to the duty question. American Family opened a subrogation file to examine a product liability case against TAMCO. It retained Hague Engineering to evaluate the shingles for purposes of that litigation. And it directed that outside counsel be contacted in order to, quote, formulate a case against the manufacturer.
Counsel, when, let's change the facts a little bit, and it's a damaged vehicle. If the insured wants to buy, say back in the late 90s, a Ford Explorer that was having the rollover issues, is it the insurer's obligation to say, look, once we pay you, let me give you some advice on how to spend it to replace what you lost?
2 points on, the answer is no, but not really the facts of our case. First of all, the information that we're saying should have been disclosed to us was information that existed before they paid the claim for the second hailstorm. And the difference, Judge Tao, is I think that your question goes to the question of warranty. Does the insurer have any obligation to say, be careful how you spend this money? We have questions about this vehicle. We have concerns about these shingles. And our claim is not premised on a warranty question at all. What we want to know is that a sophisticated, enormous corporation from the word go has said, I think we have a product defect case against the manufacturer of these shingles, but we're not going to say anything about that. And we're not going to say it despite the fact, A, that we have not yet paid the claim on that, and I think even more significantly, despite the fact that we know our insureds are going to use the same exact product again. And so I go back to the question of reasonableness under the circumstances. And on that question, there's 3 bits of evidence that I think the court has to consider. The first is Kyle Martin. He is an agent of American Family. He's the lead adjuster on this case. He says, of course I would have told Louisiana Purchase about the subrogation activities. Had I known about it, I owe my insured a duty of good faith. And he goes further and says it would be bad faith for me to have that knowledge and not say anything about it.
Mr. Fishman, at what point, in your view, does American Family have an obligation to advise Louisiana Purchase of its concerns? As you know, Judge Pratt said there is a difference between its speculation and investigation on the one hand and its conclusion on the other.
So I think that there are three possible points in time that I could identify, but I don't think we need to be that precise about it. They open a subrogation case file, they hire Hague, and they contact outside counsel. All of that occurs in October 2014, so I would say when all three of those things happen, certainly they should come forward and say, we are preparing a product defect case. Don't know if we're going to go through with it. Don't know if we could convince a jury and get a verdict, but we're looking at it, just so you know.
And Mr. Fishman, at that point in October, your client was aware of exactly the same facts as American Federal.
No, not the salient facts. All that we know is that a hailstorm destroyed the shingles. We have no idea that American Family, this enormous insurance company who's pretty sophisticated in these matters, is preparing a subrogation case against the manufacturer.
Well, your client, as I recall, had a roofing subcontractor, is that correct?
That's correct.
And could this person not have picked up on the fact after the second hailstorm, there might be a problem with these shingles that we chose?
I can't say what Mr. Shaw should have known or could have known. He's a roofer. I mean, he's not an insurance adjuster climbing up on roofs, hiring engineers, evaluating shingles. American Family rightly, excuse me, makes much of the fact that the second hailstorm was a big one. So I think it's perfectly reasonable for Mr. Shaw perhaps to conclude, I don't think I've ever seen a shingle that would withstand this thing. Broke the windows, broke the skylights. But I think the real answer to your honors question is, even if some of that, even if you have questions about what Mr. Shaw should have known, I don't see how his knowledge could absolve American Family from its obligations under the duty of good faith and fair dealing. They don't get to say, you had a roofer, he could have given you this information. I mean, you could point to, who knows, you could point to the meteorologist on 9 News and say, she said what a doozy this hailstorm was too, you should have known. So going back to the evidence, we have the lead adjuster, American Family's agent, said, I would have disclosed it had I known, because that's what the duty of good faith and fair dealing is all about. Not surprisingly, Kent Miller, our insurance industry expert, said, sure, an insurer like American Family has to disclose this information in the circumstances of this case.
Didn't he also say at his deposition that he was aware of no cases that had imposed a duty on an insurer in a similar situation?
I think there are no cases that are in a similar situation. It's a very unusual case. Back-to-back hailstorms, midway through repairing, subrogation is open before the claim is filed. So yeah, I mean, Miller, nobody said they had seen anything like this before. But I think Kent Miller was quite clear in saying, under the facts of this case, as they exist, and largely undisputed, there was a duty of disclosure. What is more surprising, I think, than our expert opining to that fact is that American Family's expert, John Carr, opined to that fact. That's 1193 of the court file. He said, sure, the duty of good faith and fair dealing would require my client to disclose the subrogation activities at issue in this case. What he did say, in addition to that, and what American Family notes in its brief, is he said, but there's no contractual obligation for it to do so, and that's fine. That goes to Judge Pratt's duty order and the question of whether you have to have a breach of contract or a breach of an express contractual provision in order to prevail on a good faith claim. And for the reasons argued at pretty significant length, I think the answer to that is pretty clear. So if there is a duty of disclosure, and while Judge Pratt ruled that there was in his June 13th order, he pretty much abandoned that when it came time to enter summary judgment on our claims. And he ruled, assuming a duty of disclosure, it could not have been breached in this case because there was nothing for American Family to disclose because it didn't know for a fact that the shingles were defective until it got the Hague report. And there's two basic points I want to make about that. The first is fundamentally misconstrues the basis of our claim. Our claim was not based on knowledge versus suspicion, what they know once they get the Hague report, do we have to wait till they get a jury verdict, do they have to file a complaint? Our case was based on undisputed evidence about subrogation activities undertaken by American Family before the claim was filed. So just as a factual matter, Judge Pratt's order is just off the mark there. The other point I want to make about that is that American Family makes no attempt to defend that ruling.
Are we talking, excuse me for interrupting, after the initial order on good faith was entered and before the summary judgment, wasn't there a meeting of counsel to talk about what the outstanding issues were that still needed to be addressed?
Yeah, Judge, the timing of that was the order is entered on the 13th of June. June 14th, there was a trial readiness conference previously scheduled. It comes out the night before. So all the trial lawyers pile into court, and the lawyers for the HOA stand up and say, I don't think we want to go through a 2-week trial here, Judge, because you've kind of killed our case with your duty order. But you haven't entered judgment against us. We need to posture this thing so we can appeal your ruling. And that's where the 4 questions come up. It's not because of confusion about how our theories changed. It's the parties saying, let's get a final judgment so we can appeal. Your duty order is a problem for us. It goes to the heart of our case. So when those 4 questions are answered and Judge Pratt enters summary judgment, he says, I'm going to assume there's a duty, couldn't have been breached as a matter of law. That's just flatly wrong because it ignores the evidence that is the basis of our claim. And the second point I wanted to make on that is American Family makes no genuine attempt to defend that order. It says, we waived it because we didn't raise it below. And there's probably a half dozen sites in our brief where we quote the argument from our papers. It's set forth in the trial management order. It was argued at length in the trial prep conference as early as May 19th, 2014. So on the waiver, the only real argument, I have nothing to add if there's no questions about the issue of waiver, and if there are none, I'll reserve the remainder of my time.
Thank you, counsel.
Good morning, Your Honors. My name is Matthew Clark. My bar registration number is 44704. I'm here on behalf of American Family Mutual Insurance Company. This case concerns the scope of an insured's good faith and fair dealing obligations and whether an insurer acts reasonably when it does not disclose information it does not know about matters that are beyond the scope of the policy's covered risks. To sort of set the very basic facts that show why Judge Pratt got it right on the duty ruling, got it right on summary judgment, and got it right with respect to the motion to amend, denying the motion to amend to add a claim for punitive damages. After a hailstorm hit the insured's properties, the HOA's properties, American Family paid them $2 million for the total loss to their roofs. The HOA's hired a roofing contractor, as Judge Vogt noted, and that roofing contractor, along with the HOA's project manager, managing agent, selected shingles that the manufacturer had rated as impact resistant. They knew those shingles were rated as impact resistant. They began shingling. A second, more powerful storm hit, and it destroyed all of the roofs that had been reshingled to that point. So at that point, the HOAs, their managing agent, their roofer, all knew that these shingles that were supposedly impact resistant had been damaged within days of being installed by the first hailstorm they encountered. And following that storm, as it was obligated to do, American Family paid out $1 million to cover the loss for that. American Family didn't wait to have an engineer up on the roof to inspect the shingles. It paid long before any of that happened. In the papers, you'll see references to, well, if there's a third storm, is American Family going to pay? There's the HOAs try to make an argument about what the agreement says, but the fact is the HOAs have already paid to replace the shingles that didn't perform as rated, and they stand ready to do so again.
You said the HOAs stand ready. You mean
I'm sorry, American Family stands ready. Absolutely. Thank you, Judge Vogt. And so against this backdrop, American Family believes that Judge Pratt got it exactly right. As a matter of law, Colorado imposes no duty on an insurer in American Family's position to select the materials that its customer uses, to supervise those materials, or to share speculations about what might have caused materials to fail. On the summary judgment order, he was correct again that American Family has no duty to disclose the unknown. It is reasonable to not disclose what is not known.
But what about what was known?
Well, what was known was the same for the two parties, that shingles had been put on, the manufacturer represented that those were impact-resistant shingles, and they failed at the first hailstorm that they faced. These are parties in a first-party context. American Family doesn't owe fiduciary or quasi-fiduciary duties to the insured. The parties have obligations to protect their own interests.
So if there is a duty to disclose, is that duty abrogated by the fact that the party to whom disclosure is required has another avenue of learning it?
Well, I don't think there's any duty to disclose this information.
I understand. That's why I stated it as a premise. If there is a duty to disclose, does the disclosure no longer need to be made if the party entitled to disclosure has another avenue of learning the information?
I'm not sure I see that hypothetical here. I will say, I think the answer is yes, there's no duty to disclose there. I think there's no information here that was withheld. So I don't think that this is a case where something wasn't disclosed.
Well, the assertion is that what you didn't disclose was more than just speculation. It was pretty firm suspicion. The question that I have for you is, does the mere fact that there might have been another avenue for the party to have known the information, in other words, what Judge Vogt had asked about, couldn't they have concluded on their own that these shingles were not what they were purporting to be? Doesn't that go more to damages or to causation of damages than to the duty itself? And isn't what we're facing, was the duty decision correct?
I mean, I think if they know the information, I don't see how. I don't see that there's a duty here to disclose the information. I think that they had the same information, so there's no the impact of. There's just no legal impact of if American Family gave them that information that they already had. And again, I don't see what the information was, what the facts were that American Family had that weren't shared.
That you opened a subrogation file.
Well, they started.
Could they have even known that?
What?
Could they have even known that without you telling them?
Probably not. And that, I mean, I think that gets us back to the duty issue. You know, Judge Vogt asked about, are there any cases about this? And it's remarkable that in the briefing there is no citation to any case that holds that an insurer needs to inform its customer of its subrogation claim or activities.
Mr.
And that's
Clark.
because I think that is the insured's claim. At that point, American Family had paid the insurer's claim. American Family had paid the insured the full amount they were entitled to under the policy. They had paid them everything they'd done. They investigated the claim. They didn't need the engineering report to complete that investigation, to determine that the roofs were a total loss, to determine what their obligations were, what within the scope of covered risk.
Mr. Clark, I think in some ways the essence of Louisiana Purchase's argument is that the duty of good faith and fair dealing extends beyond the terms of the insurance contract. Do you agree with that?
I do agree with that.
So what is the line then between saying that that duty extends between the terms of the contract and the circumstances here where you say that the duty does not apply?
Well, I think there are a couple of things. I think you can look at the Dunn case. I think that's a very good analog here. And in the Dunn case, the court recognized the line of authority that you mentioned, Judge Taubman, and but the insurer in that case didn't have a duty to supervise the contractor that performed the services that were at issue and that were claimed to have been done poorly. And that was a case where the insurer actually recommended that contractor. And still there was no duty because, again, this insurance policy contains an exclusion for materials. It's not within the scope of the risk that American Family agreed to accept, that the parties contracted for. It's not what the HOAs purchased from American Family. They didn't purchase advice or knowledge about shingles. They didn't purchase what, in certain circumstances, I do think amounts to a warranty, to the fact that American Family will take steps to ensure that the right shingles get on the roof. That's just simply, that's explicitly excluded from the policy.
Mr. Clark, then what is the effect, if any, of American Family listing the Tamco shingles on its website as an approved source of shingles?
Well, they are approved in the sense that those shingles could qualify certain residential customers for premium discounts. The HOAs have a business owner's policy. It's undisputed that when they asked their insurance agent whether they qualified for a deduction based on using shingles on that list, that they were told no, that is the evidence of what the agent said. Now, through a bizarre sort of almost like kids' game of telephone, by the time it got back to the board, that no had turned into like a maybe. But the undisputed evidence is that the insurance agent said, no, you're not, that a discount isn't available to you. More to the point, the undisputed testimony also shows that neither Mr. Jacobs, the managing agent, nor Mr. Shaw, the roofing contractor, looked at or relied upon American Family's list on the website or marketing materials. Mr. Shaw knew the list existed, but neither of them looked at that in deciding which shingles to purchase. Furthermore, both the website and the marketing materials contain clear, explicit disclaimers that say that American Family is not recommending or warranting any of the products on here. It's purely for the purposes of whether certain residential customers can get discounts, policy discounts. Getting back to some of the cases, the key cases I think from American Family's perspective are the Dunn case, which I've mentioned, which, as a matter of fact, cites to the Lyra case for the proposition that the court declines to extend a defendant's duty to act in good faith to require it to undertake obligations that were expressly conferred on plaintiffs. Selection of materials is expressly conferred on plaintiffs. It's excluded under the terms of the policy. Similarly, the Bailey case, Bailey v. Allstate, makes an important point that an insurer is not required to pay non-covered claims which fall outside the coverage as dictated by the contract. Good faith and fair dealing is not enough to place the broad and substantial duties of a true fiduciary on an insurer. It's under Colorado law, the duty of good faith and fair dealing is not something that can allow, in the first-party context, an insured to essentially impose fiduciary duties on an insurer, to have the insurer be responsible for protecting that party's interests beyond the scope of the contract. As to the subrogation issues, I direct the court's attention to the Ferrellgas case, which talks about an insurer standing in the shoes of its insured as to a claim that the insured no longer can recover on the reimbursed portion of that, and that an insured can't interfere with an insurer's settlement of a subrogation claim. Similarly, De Herrera versus American Family points out that an insured can't accept the benefits of the policy and then reject the subrogation rights. And finally, before he was hired as a paid expert in this case, Mr. Miller, the HOA's expert, in his Colorado Practice Treatise noted that where an insurer acts in compliance with established laws and the terms of an insurance contract while seeking subrogation and reimbursement, it could not have acted in bad faith, and summary judgment in the insurer's favor was proper. And that is exactly the situation we have here. The HOAs have never identified any law that they claim American Family has broken. They agree that American Family hasn't breached any term of its insurance contract, and yet they're trying to bring, to say that American Family is acting in bad faith when it pursues its own subrogation claim.
I don't think they're angry that you're pursuing the claim. They're angry that you didn't let them know that you were so that they could act accordingly as well. But let me give you a hypothetical.
Okay.
And I'll change it from my hypothetical to Mr. Fishman. The insurance policy at issue says we'll pay for a lawyer if you're sued. You get to pick your lawyer. And the insurer picks a lawyer, and the insured says, we've had to sue this lawyer for malpractice 12 times. Do they have to tell the insured?
So it's an
or can they just say, okay, we'll pay for the terrible lawyer just hired?
The insurer's obligation is to provide a lawyer?
Yes.
Well, I mean, maybe in that situation, but American Family's obligation was not to provide shingles or advice about shingles. That's why this is so different. There's just, the shingles are outside the scope. American Family figures out whether there's a casualty loss, and they reimburse them for the loss. That's the protection that the parties bargained for here, and that's the protection that it's undisputed American Family promptly provided twice. And then American Family went beyond that, and they sent out an engineer, and the HOAs knew there was an engineer because they went up there on the roof with them. Their managing agent went up on the roof with him to inspect the damage and helped him grab shingles so that he could take them for testing later. And they knew the results of the testing when American Family gave them the results of the testing, even though it had no obligation under the agreement to do that. American Family's outside counsel offered to represent them in their own cause of action against the manufacturer for the fact that the shingles did not perform as rated.
Thank you, counsel. That's your time.
Thanks.
Mr. Fishman.
Thank you. A couple quick points. Judge Taubman, if all we had was a recommendation on a website about how these shingles are great, we wouldn't be here. And if all that we had was a complaint that American Family didn't select shingles for us, we wouldn't be here. And if all we had was a complaint that they didn't supervise our roofer, like in Dunn, we would not be here. None of that has anything to do with the factual basis of our good faith claim. And it is remarkable to me that Mr. Clark will stand here and say, we knew everything about this matter that American Family knew, when our claim is based on opening a subrogation file, hiring an engineer to support a product defect case, and contacting outside counsel to formulate a case.
What would your clients have been able to do had they known those facts in addition to
Right.
knowing about the
So
shingles?
that goes to another misstatement. The claim was not paid at the time those things occurred. The claims had not been paid. And the undisputed evidence by both presidents of the HOAs, I believe, I could be wrong on this, I believe it's court file 1080 and 1082. Both presidents said, if we had known this information, we would never have used the Tamco shingles a second time. And why would they? I mean, why would they take the risk when they know that a corporation like American Family is poised, or at least preparing and thinking about a product defect case? Why would they take the risk?
But that boils down to an assertion that the obligation on the the insurer was to protect or to advise in how to purchase, what not to purchase. How is that not imposing a fiduciary obligation rather than just a good faith obligation?
Well, I disagree that that's what we are saying. We're saying, tell us the actual concrete things you're doing to prepare to sue the manufacturer. Don't tell us what products to use. Don't tell us that there's a warranty problem here. Just tell us what you are doing. And, you know, it is true, there are no cases on point that go directly to sort of circumstances like this. But frankly, I think that's a measure of how kind of outrageous American Family's conduct was in this case. It just doesn't happen. You have their own adjuster, you have our adjuster, expert, and you have their expert, John Carr, all saying these actual things, not warranties, not supervisions, all of this should have been disclosed under the duty of good faith and fair dealing. And what we don't have, even to this day, is any justification whatsoever for American Family's failure to share that information with us. They've never explained why they didn't do it, and they've never tried to explain why their decision not to do that was reasonable. All they've done is made arguments about the scope of the duty, and there's no breach of contract, and et cetera, et cetera. So, I mean, the evidence that you have before you when you have to decide what a reasonable insurer would do under these circumstances, it all points to only one conclusion. And it has nothing to do with Dunn and Lear, Dunn, where the court says you don't have an obligation to supervise a contractor. It's not the basis of our claim. Lyra, where you have a contract that specifically excludes coverage for punitive damages, you can't use the duty of good faith and fair dealing to contradict those terms.
And thank you, counsel. Thank you, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. We will now be in brief recess while we again reconstitute the panel for our 10 o'clock docket. The bailiff may so announce. Be seated, folks. For those of you who have been with us all morning, you're going to hear the same speech all over again. Good morning again. Welcome to Division I of the Court of Appeals. My name is Judge Ted Tao. To my left is Judge Dan Taubman. To my right is Judge Michael Berger. Together, we are the division assigned to hear the matter set on our 10 o'clock docket, which is 18CA1337, People in Interest of ARC. Are the attorneys present on that case? And have you received the handout regarding the procedures and have any questions?
No questions.
I like that compound question. That was good. Back to my trial days. While we will likely refer to you as counsel, we may use your name or names of parties, although here we're likely to be using initials. But if we mispronounce a name or misuse a gender pronoun other than one that is preferred, we do apologize. Please simply correct us and we will endeavor to get it right from then on out. Remember that the arguments are being live streamed on the internet and will be archived, so if there is sensitive information, please take care in how you discuss such matters. On that note, if anyone in the courtroom has a cell phone, please make sure it is turned all the way off and not just silenced, so as to avoid interruption as well as interference with the streaming signal. Each side has 15 minutes for argument. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. Let's begin.
Good morning, Your Honors. May it please the court. My name is Tara Yorfall, registration number 46193. I represent the juvenile appellant ARC. A juvenile sentence must be based on legitimate concerns of rehabilitation. A juvenile sentence must also be based on accurate and sufficient information. Neither of those standards were met in this case. At 13, ARC was sentenced for a heinous sex offense. At 17, he was provided an opportunity for a new sentence when his sentence became illegal. At the hearing, the court was presented with tremendous information of his rehabilitation. An undisputed record shows that ARC had been successfully rehabilitated and had been successful with his behavior and academics. His treatment provider, a sex offender evaluated, and a forensic advocate discussed this success, that he was nearly completed with his treatment, and that it would be much better for him to go home after a short transitional period rather than be placed in a step-down program. The testimony indicated that there was a risk in this case of overcommitment, and that came directly from his treatment provider as well as the sex offender expert. The recommendations were supported by social science exhibits that showed that in general, sex offenders, even that commit serious crimes, could be rehabilitated and finish their treatment within 8 to 28 months, and that it wasn't a risk of having these individuals in the community, despite having committed serious sex offenses. In addition, overcommitment would result in increased recidivism rather than the opposite. Specifically, this was through more association with antisocial peers, retardation of normal adolescent development, lack of parental support and guidance, decreased mental and physical well-being, and decreased educational and employment opportunities throughout a lifetime. The court adopted the evidence and the testimony presented. Specifically, the court said, if this were just about you, ARC, you would be going home. But we have to also consider the nature of the offense. Damage has to be paid for what you did. This sentence was contrary to the Children's Code. The Children's Code requires that a juvenile sentence be based on rehabilitation. Now, the Attorney General does not dispute that the primary principle of the Juvenile Code is rehabilitation. But the issue before this court today is whether punishment can also be considered in fashioning a juvenile sentence. I would argue that our cases, Bolstemon, SGW, AS, and WP, all are Supreme Court cases that discuss the differences between the criminal justice system and the juvenile justice system, make it clear that these ideas of deterrence and punishment are separate and distinct from rehabilitation in the interest of the communities.
Not one of those cases says that punishment cannot be considered at all, does it?
Yes, Your Honor, and I absolutely agree with you there, but they say that these systems are distinct and separate. And I would refer you to the Maryland Court of Appeals decision that says if the court is considering punishment, then it would be rendered meaningless, the court's job to consider the treatment and rehabilitation that is needed for the juvenile. And this case provides the perfect example on why punishment and rehabilitation are not compatible. Specifically, we have on the record that it is to the detriment of ARC and society to keep him committed. Now, arguably, a step-down program could be considered rehabilitation, but in this case, that is not the record we have before us. 15 months of step-down was appropriate for the rehabilitation, and in the long term, this is going to increase his recidivism by associating with antisocial peers rather than being with parents that, on the record, were prepared to take him in, supervise him, and have him get on with his life.
That's a slight overstatement, isn't it, counsel? There's a risk of that, but there's no way to say that it will happen, is there?
Oh, right, we
The
can't.
evidence is that overcommitment carries risks, not a causal connection. I mean, not a necessity, not an inevitability.
Well, right, yes, Your Honor. We can only judge and consider the protection of the society based on evidence and based on the information we have before it. I don't think anyone can predict the future that I know of anyway. But based on that information, the consistence with the social science and with his treatment provider, an expert, and a forensic evaluator all recommended that there was a serious risk of overcommitment that would increase his recidivism rather than decrease it. I would also like to go into the court's order on the step-down program being appropriate, because there was an objection that punishment was too much of a focus, and the court responded that, well, I believe step-down is appropriate. That statement is not sufficient to justify the sentence. Specifically, there wasn't accurate or sufficient information to put that, and due process requires that the court state the reasons behind that on the record. And there's nothing on the record to support that a step-down program would be appropriate in this case, and specifically an additional 15 months to allow for that step-down program. It was the prosecution's burden to show beyond a preponderance of the evidence that a step-down program would be required for the rehabilitation. The only thing we have on the record is the prosecution's opinion that he thought, considering the nature of the offense, that a step-down program would be appropriate. But as testified by the three experts, or the three witnesses, in addition to the exhibits presented, just because you have a serious sex offense does not make that individual at risk for recidivism or require extra time and commitment. And so there was just nothing to support that.
Ms. Urfeld, why do you think that a step-down component of the sentence was inappropriate?
Well, because step-down is equal to commitment, and here he's going to be around antisocial peers instead of with parents. And addition, the same risks of overcommitment, your mental health and your physical health are diminished due to the stress involved in any type of residential treatment program. And this is a 17-year-old who's been dealing with this at 13. The support that he could get at home with his family would be much more healthier for him and to start his life. In addition, he wasn't going to be just left out. His parole period where he could get treatment in society and the programs would still be available for him with outside a step-down program. And the issue here is not whether a step-down program would be appropriate or not. It's really what is on the record to support that. And right now, all we have is a record that is contrary to saying that a step-down program was appropriate. You have the chair of Lookout Mountain Youth Services, who is his treatment provider, saying, given his family support, that what Lookout would do would be to send him home rather than step down. And the chair also mentioned that his greatest risk is being around other peers in delinquent behavior. And I would just point out to the cases that this is very similar to our cases Valencio and Tuffo, which in each of those cases you had an expert opining in Valencio that one of the SVP factors was met. And the court found that that's not enough. Just an expert opining with that without any substantiated information to back it up was not enough. Likely the same situation in Tuffo where the PSI said that the defendant had failed the first grade. Just a statement alone, either an opinion or a statement by a probation officer that doesn't have the first-hand knowledge or anything to support it is not sufficient. So due process was not met in this case, regardless of whether punishment can be considered in the Children's Code, that there was this finding that a step-down program was needed, but nothing on the record to substantiate that. If there are no further questions, I will reserve my remaining time for rebuttal.
Thank you, Gail.
Good morning, Your Honors. May it please the Court. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. This case is a routine consideration of a trial court's considerable discretion in imposing true sentence on a juvenile offender rather than an adult offender, but the principles remain largely consistent. Here, the sentence that was ultimately imposed was consistent with the legislative declaration and by statute, was consistent with the facts of this case, and was consistent by the trial court's own explanation in issuing the ultimate sentence. And I think it might help to start off by addressing what the original sentence was, because that helps frame, I think, the trial court's understanding of the sentence that it was then going to impose. And the original sentence as imposed was a 3 to 5 year indeterminate sentence. Now, of course, this past year, a division of this court ruled in People in the Interest of JC that an indeterminate sentence under the Children's Code is an illegal sentence, and so it went back for resentencing here. But I refer to that original sentence because of the date range that it gave, and it gave a minimum range of 3 years and a maximum range of 5 years. And the sentence that was requested here by defense counsel was a sentence that was well below that minimum 3 year mark from the outset. And the sentence that the trial court ultimately imposed was 1.5 years below that maximum mark. So really what we're talking about is a 6-month period of time difference between the minimum and what was ultimately imposed here, which means that we did have a very, very significant reduction in the first place. Now, the legislative declaration, and please humor me as I read parts of this. I don't have all of 19.2.102 memorized just yet. But the General Assembly made a declaration that said the intent of this article is to protect, restore, and improve public safety. Those are the first words out of the legislature's mouth in this situation. But then the very next line, it says, the idea is to create a system of juvenile justice that, quote, will appropriately sanction juveniles. So punishment is very much part of the analysis. And it goes on to say, we, the legislature, are holding paramount the public safety, and the juvenile justice system shall take into consider the best interests of the juvenile, but also the victim and the community. And then in subsection 2, it goes on to talk about how the public has a right to a safe and secure homes and communities, and acts of juvenile delinquency make the public unsafe. That's enough of that. I bore you with that for the simple purpose of suggesting that this idea of treatment and this idea of punishment are not so distinct as opposing counsel would have us believe. They are intertwined. They are appropriate sentencing considerations for a juvenile defendant and for the judge in this case.
Doesn't your argument run the risk of ignoring several cases that make it clear that the considerations are different between the adult system and the juvenile system?
I see Your Honor's point, and I don't think so. I think they're actually very well harmonized. I think it's just the statute makes clear that you have to elevate these considerations of rehabilitation and the best interests of society as consistent with the best interests of the juvenile, because the goal is ultimately to rehabilitate, but it's not rehabilitate to the complete detriment or the complete ignoring of a punitive or sanctioning aspect. And that's consistent with what our Supreme Court has said in WP and in Bosselman and the other cases cited in the briefs. So I see that a contrary ruling could potentially do that. For example, if a court just said, I'm going to send you to prison with no treatment, that would run contrary. But here we have an elaborate treatment scheme that clearly is underway, and I think importantly, based on the facts of this case, was still underway at the time of the resentencing hearing. There was ample testimony about how there were several more months of treatment to go, there were several numerous risk factors that were still involved, there were still numerous issues of potential future delinquency based on this juvenile's still behavior. The opposing counsel talked about how the prosecution didn't prove anything at this hearing, but a lot of the proof for this came in through the trial, through the discussion of the juvenile's offense, and through his subsequent rehabilitation. This wasn't a 35B sentence reconsideration. This was a resentencing based on an illegal sentence. So the court was essentially issuing a sentence based on that original crime, but also now taking into account the progress that the juvenile has made. And it's not insignificant progress, but the progress that the juvenile had made. Yet the evidence did not clearly establish that this juvenile could be set free in the community and not reoffend.
Mr. Michaels, was there any concern about ARCs being able to be returned to his parents?
There was. The court made a note that it thought that, I think it said the mother was still somewhat in denial about the offense. My recollection in looking through the record in preparation for today's argument was that the father said something to the effect of he thought his son was just in the wrong place at the wrong time. But there was concern about whether or not the family would be suitable, and that's based in the record support and in the trial court's findings that specifically reference that. And I think that just goes to this idea of continue the treatment, make sure he doesn't slide back, make sure he's motivated to finish treating. Because the testimony from the forensic provider and the defendant's experts throughout the resentencing sort of said originally he wasn't amenable to training. He wasn't doing very well, and it's just been very recently that he's turned around and started making this change and started being invigorated. The continued sentence allows to continue to push that treatment, to continue to incentivize that particular juvenile to succeed in treatment, quite honestly. Now, the court, when it made its findings, reflected on the nature of the crime, and that's consistent with the legislature's declaration in 19.2.102, where it says we have to consider the victim, we have to consider the impact on the community. It reflected on the purpose of the juvenile statute, so it identified that rehabilitation was part and parcel of the consideration. And it commended the juvenile for the accountability. The juvenile himself said, I'm working to push past some very uncomfortable spots to push my boundaries. But even that admission is saying, I'm not there yet. And I think that's important to realize that we're talking about a sentence that is still below, a requested sentence that's still below the minimum that the trial court would have imposed. The sentence that the court imposed was a significant reduction, 18 months from the maximum. So it recognized that the juvenile is in fact doing quite well and is in fact amenable to treatment and will in fact be rehabilitated before that 5-year mark. The court's opinion was that it's not smart just to let the juvenile out into the community. It recognized all the authorities and all the social science studies that were introduced below, but it said this is not appropriate. And there was no testimony at trial that suggested that this juvenile was in danger of overtreatment. There was just discussion about how overtreatment could be a concern, but they didn't root it in this juvenile, especially considering the amount of treatment he had left to do. If there are no further questions, I would just remind this court that just because a defendant, a juvenile in this case, is succeeding and is responding to treatment, does not mean the treatment should necessarily end early or be cut off before it's fully completed or be cut off before the juvenile has established that he can succeed without that treatment, that he can use those lessons that treatment has imposed and move forward. It doesn't mean that a reduction of sentence below the original minimum would be required. And so, again, the court reduced the sentence and reduced it quite significantly here. If there are no further questions, I would ask that this court affirm. Thank you.
I think it's important to address the word what is a sanction in a juvenile case because it is in the Children's Code. I would just refer this court back to Galt and Kent and MC that all talk about how committing a juvenile to commitment is akin to incarceration. There's no disputing that there is a penalty in that sense that you are depriving this juvenile of liberty. And I believe that is what the Children's Code means by sanction. And the Supreme Court case Bolstemon, who talks about that a sanction is based on rehabilitation, makes sense that there is a penalty suffered by the juvenile, but it is not based on punishment, but rehabilitation. I would also add that the concerns about protecting the community that are mentioned in Section 2101 that was read by Mr. Michaels, those were met by sending the juvenile home. That is what the evidence supported at the hearing, not necessarily keeping him in the step-down program. We would be in a very different case if the court had said that I thought step-down was appropriate for rehabilitation for X, Y, and Z. But we don't have X, Y, and Z. What we have the court saying is if this was just about you, ARC, then I would be sending you home. But we have to take into account the nature of the offense. And the crime you committed has to be accounted and paid for.
Doesn't the code itself counter your argument? Aren't there provisions of the code that are clearly punitive? Aggravated juvenile offender sentences, that type of thing.
And I would refer, and I would argue.
And let me be clear, not solely punitive, but
right,
clearly
so,
punitive in part.
Well, so I think you're referring to Mr. Michael's argument that for F1 and F2s, there's no chance of probation, right? And I would argue that what the legislature was doing there was saying that for some serious offenses, that some minimal level of commitment is required. I don't think that's necessarily a punitive step, but a finding by the legislature that certain commitment was needed due to the seriousness of the crime. Since this code has been created, there's been a lot of development, including in Exhibit E, that shows that theory is wrong, and we'll see whether our legislature adopts that. But we can simply say, just because that a minimum sentence was required, that we don't know without a full legislative history analysis on whether that was for purposes of safety or punishment. There's nothing specific in the code to say that a minimum sentence for a serious crime is necessarily punishment when created by our legislature. If there are no further questions, I would ask this court to vacate the sentence and resentence ARC to 27 months. Thank you.
Thank you, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. That concluding our docket for the day, we will be in recess, and the bailiff may so announce.